Good afternoon, everyone. My name is Deb Van Dyke Reese, and I want to welcome you to this Court Improvement Project webinar on structured decision making. Just so you know, the webinar has been approved for 60 minutes of continuing legal education, and for the attorneys who are joining us today, we ask that you type in the chat your name and bar number. This information will be submitted to Attorney Services following the webinar. In addition, the presentation is being recorded and available on the CIP YouTube channel next week. The 2017 Child and Family Services Review identified that courts and stakeholders requested education on structured decision making. Earlier this year and towards the end of last year, CIP and DHHS partnered to develop an SDM bench card, which you should have received with a reminder for today's webinar. Also, just so you know, in that same email, there was a link to the slides of the presentation. So without any further ado, it is my pleasure to introduce Jay Judds, CFS Legal for the Southeast Service Area, and Justine Nelson, CFS Supervisor from the Central Service Area. Thank you, Justy and Jay, for being with us today, and I will turn it over to both of you.
I appreciate that. I'm going to go ahead and get things started here. As the slide on your screen should show, SDM is a set of research and evidence-based tools for important decisions in the life of a case. Using SDM's assessments brings everyone together with a common set of criteria for decision-making and common language to describe the reasoning behind those decisions. Research has demonstrated that when decision makers, who generally in our situation are caseworkers, know exactly what information to consider and what to ignore, that they do better. Children and families will experience treatment that is more equitable and more consistent. For those of you who may have been around prior to 2012 when this was first instituted, may remember that there was a lot more subjective decision making. The goal of SDM certainly is, one of the goals is to be more of an objective system. So the SDM model is a suite of assessment instruments that promote safety and well-being for those most at risk, from children to vulnerable adults. The SDM model combines research with best practices and offers workers a framework for consistent decision making, and offers agencies a way to target in-demand resources towards those who can benefit most. Some of the research that's been done goes back as far as 1997. There was independent research, publication and evaluations in 1997 that I'm aware of, 2004, 2011. There's peer-reviewed publications from 1999, 2000, and 2005 that support the SDM models. The structured decision-making model for child protection assists agencies and workers in meeting their goals to promote the ongoing safety and well-being of children. This evidence and research-based system identifies the key points in the life of a child welfare case and uses structured assessments to improve the consistency and validity of each decision. The model additionally includes clearly defined service standards, mechanisms for timely reassessments, methods for measuring workload, and mechanisms for ensuring accountability and quality controls. To date, no set of CPS assessments has demonstrated the degree of reliability and validity, nor the improved outcomes of the SDM model. The goals of the SDM system are to reduce subsequent harm to children, which would be another investigation, a substantiated finding injury, or placement, and to expedite permanency, so sending children home as swiftly as safely possible or moving to a different goal as swiftly as possible. By the time a family is involved with Children and Family Services, obviously something negative has happened or we suspect a negative incident. And our goal using structured tools is to prevent the next negative incident. SDM focuses both on safety and risk. SDM was piloted first in Nebraska in 2012, went statewide in 2013. Many states across the U.S. utilize this model as a means of driving case management decisions. Nebraska has made some additions to the model, integrating narratives in the assessment tools to provide evidence as to why decisions were made. And Nebraska continually monitors the fidelity of the model for each assessment through an internal CQI process. Nebraska has completed an external reliability evaluation with the NCCD in 2016 to look at the intake, safety, and initial risk assessments. And then DHHS has also entered into a contract with NCCD to conduct another fidelity review that will look at how all the tools are currently used and identify any modifications that need to be made to better fit the policy and practices change. And now Justy is going to go ahead and take you through some of the next slides.
Just going to kind of discuss what each of our assessments are and how we use them. First of all, our workers receive about 290.5 hours of training, and out of that training, 77 of those hours are specifically in SDM. So they do receive really extensive training in SDM. So really, this is just a quick overview of our assessments and what all of them are. If you have any questions specifically, go ahead and put them in the chat and we'll try to address them when we're done. So it all begins with the intake, which is when someone calls a concern into our abuse neglect hotline. So the intake worker looks at the information and runs that through our intake screening definitions. They always have to see if the concerns impact the child. So if it's something about drug abuse by the caretaker, they need to see how that impacts the child and how severe that may impact the child. They will decide if that's going to screen in, if we're going to do an investigation, or if that's going to screen out. If it doesn't meet definition and it's going to screen out, someone else looks at that just to ensure that that's correct. If it screens in, then they decide what priority that gets. The priority will be dependent on how quickly we go out and we investigate it. A priority 1 means we go out within 24 hours. Priority 2 is within 5 days, and those are calendar days. And then a priority 3 is within 10 calendar days. From there, we do 2 assessments within the initial assessment phase. And within the initial assessment phase, we're assessing 2 things. It's safety and then it's risk. So you can see on our little chart there, we have the maltreatment occurrence, and that happens within that day 1. That's what we're assessing. So safety is the imminent danger, and that occurs right away. Our safety assessment is just assessing that imminent danger. And then risk is the likelihood of future danger. So we're talking about within 1 to 2 years, what's the risk of further maltreatment. So those are 2 terms that I think get interchanged a lot, but for the department, they're 2 very different terms. When we talk about safety, that's right now, is that child safe to remain in the home? And then risk, are they going to be safe there long term? And those are 2 different assessments we do, right? Initial assessment, so within that first 30 days. So when we make first contact, we do the safety assessment, and that's what we're going to talk about first. The safety assessment, we have specific safety threats we look at. There are 11 of them, and I won't go through them all, but just some examples of, I guess, probably our common ones would be caregiver caused serious physical harm to the child or made a plausible threat to cause serious physical harm as indicated by any of the following. And then there are some kind of subsections. One would be current excessive discipline or physical force or domestic violence likely to injure the child. Another one we use pretty commonly would be caregiver does not, cannot, or will not meet the child's immediate needs for supervision, food, clothing, and or medical or mental health care. Needs may be basic or exceptional. So those are some examples of what our safety threats are. And these are objective, not subjective. Like Jay was saying, there used to not maybe be very objective things that workers could look at. But our safety assessment form, when a worker goes through and fills it out and puts in their narrative, it's probably only going to be a few pages long. But when our workers do their training, these are, I mean, they're probably like 10 pages long because every single safety threat is really outlined for what exactly is excessive discipline, what exactly does lack of supervision mean. So just so everyone is aware, those really are spelled out within the workers' SDM training so it's not subjective. So the worker in Lincoln will think the same as the worker in Broken Bow, which is the office I work out of mainly. So they go through in their assessment to see if any of those safety threats would match. If there are no safety threats in that home, then that child's going to be considered safe. And what that means is that there's no imminent harm going to happen to that child, which means, you know, within those next few days, within that week, whatever, no imminent harm going to happen. If one of those safety threats is found to be in that home, then we look to see if we can do a safety intervention that can keep that child in the home. If there is, then we find that child conditionally safe and we safety plan around it. That parent has to agree to that safety plan to be able to find them conditionally safe. So we could have a safety monitor in there, someone who would go check, you know, daily and make sure that mom and dad are doing what they need to do. We could also have mom agree to have the kiddo go stay with grandma, something like that, and grandma can be a safety monitor. If there's no way that we can assure safety with a safety plan, that child's going to be unsafe. And we have to either request court intervention or request that law enforcement put them in a 48-hour hold. We also have a section for child vulnerabilities, things like the child's age, if they're 6 or under, if they have medical conditions, mental health conditions that impact their ability to protect themselves. That's important as well. For instance, if you have a dirty home or unsafe home, but has a 16-year-old in there, that's probably not going to be an issue because the 16-year-old can probably assist in cleaning that up. But if you have a 2-year-old in there, then that could very well be a safety threat. So that is our safety assessment. We fill that out within 24 hours of the first victim contact. It has to be finalized within 4 days of that, so that's kind of the timeline. From there, we do the risk assessment. And once again, risk is within, 1 to 2 years. What's the risk of future maltreatment for that child? This has to be completed within 30 days of accepting an intake. We have 16 domains we look at in the risk assessment. So it's not just that one incident, what happened in that one incident, but a large variety of what's going on with that family in a whole. So you look at their past involvement with the department, open cases and intakes. You look at that child's vulnerability. Do they have mental health issues? Do they have past behaviors? Look at how many kids are in the home, how old they are, if you have little babies in there. if the caregiver is blaming the child or justifying the maltreatment of it, if they have any mental health issues, substance abuse, domestic violence, if the home's safe or if it's not safe, if they're homeless, just a wide variety of issues, and that's going to give us a risk score. Oh, as well with that, there's either risk or prevention. They're very, very similar. Prevention's just for dependency cases when there's no abuse neglect, but they're very, very similar. So with our risk scores, if the family scores low or moderate risk, which would mean low or moderate risk of having any maltreatment in the next 1 or 2 years, we're going to recommend case closure, and we're going to refer to any appropriate community services. The child also has to be safe. If the child's not safe, conditionally safe or unsafe, we're not going to recommend that the case closes, obviously. If it's high or very high risk that there will be maltreatment, or if the child is conditionally safe or unsafe, we're going to recommend that we open a case. And that can be a voluntary case or that can be a court case, just depending on what's going on. Oftentimes, if we staff kind of within the department, staff with the county attorney, we don't feel like there's enough for a court case, and we would ask the family if they want to do a voluntary case. I would say more often than not, the family says, no, thank you. So we say, all right, and then we refer to community services, and then we just kind of have it all documented in case they would come in again. And oftentimes these high and very high families, they do come in again because that's what the tool tells us they will. So that we may get another intake, and then we'll see, that we've offered services, before, and if that should go to court, that'll show us, the pattern as well. So once again, this is within 30 days, safety assessments within just a few days. That's when those will be done. Okay, so if the case closes out, then we're done. That's all the assessments we'll need. If the case goes to ongoing, we're going to do a family strengths and need assessment next. And what that tells us is what we're going to base the case plan around. So what this looks at a number of domains. For adults, there's 8, the caregivers in the family. For children, there's 12 domains that it looks at. So for the adults, it looks at like their coping skills, their substance abuse, if there's any problems with relationships, if they have financial stability, any health issues, those kinds of things are what it focuses on. It also looks at every single child in that household and what their strengths are and what their needs might be. It looks at their emotional and behavioral development. It looks at their education, any kind of sexualized behavior. The older kids, it looks at their life skills and how they're doing with that. It also looks at substance abuse, how they are with their peers. It's just kind of a large, comprehensive assessment of what they're doing well at and what they're needing some help with. Ideally, this should really be showing us the things that they're doing well at should be able to help us, and we should be able to build on those to help them with the things they aren't doing so well with. So once we gather that information, put that in the assessment, we are going to prioritize it. This is kind of what it looks like. And we show if it's related to a safety threat, if it's related to anything else in that family we're worried about. Are they willing to address it? And do we need to prioritize it for our case plan? Every now and then, the family is absolutely not willing to address something. And you may not be able to put it, or we are not supposed to put it in our case plan if they're not willing to address it. I do think our workers do a really good job at being able to engage families. For instance, if it's a court-involved case and on substance abuse and they really don't want to work on their substance abuse, but I think they're very good at being able to engage them and letting them know, hey, you're really going to have to work on this. You know, we understand you don't think it's a problem, but the court's really going to need to see you work on this. So hopefully you aren't seeing a lot, I guess, of reasons that people are adjudicated not being in the case plan. So that's what the family strengths and needs are, is really seeing what the family's struggling with, hopefully getting strengths in there to be able to kind of build up how we can help them with their struggles and getting the case plan built around that. This assessment is done every 6 months. It should kind of coincide with how often we're doing case plans as well. We can do it every 3 months if we need to. Sorry, I missed it. Okay. From there, if the kids are at home, we do a risk reassessment. We do this every 3 months. And what this tells us is if the case should stay open or if the case should be closed. What we look at in this assessment and what we score is their prior history with the department. If the caretaker has had any abuse or neglect in their history, and a lot of these are similar to a risk assessment, it's the risk reassessment. The characteristics of the children, again, mental health and substance abuse of the caretaker, if they're meeting their physical needs, and then, of course, their progress with the case plan. So this is very similar to the risk assessment. If they score a low or moderate, we're going to ask for case closure. If they score a high or very high, then we're going to ask for it to remain open. And we do understand, too, that there's a lot of other factors going on. If it's a court case and there's a family team involved in things, but these are this is the assessment that we like to use just objectively see, is this a case we should keep open, or is this a case that we should be recommending for case closure on an objective level? Along with that, we are assessing for safety the entire time. Anytime there's a change of circumstances in that home, and change of circumstances include a large variety of things, but if there's another incident in the home, if mom has a new baby, that'd be a change of circumstances. If there's a big blow up in the home, if mom brings her boyfriend in the home, we should be doing a new safety assessment and see if there's any safety threats that are being met. Okay, if those kiddos are out of home, we're doing a reunification assessment, and that's every 3 months as well, to see if that kiddo can go home. So in that, just a second, oops, sorry. There's different domains we look in there. We're reassessing the risk and looking at our old risk assessments to see where they scored and to see if any new intakes have came in the meantime. We're looking and seeing how visitation is progressing, if those visits are still supervised or not supervised. We're going to see if there's any new safety threats in that home or not. We're seeing what their progress is on the case plan, if they've learned any new skills or if they're not doing very well on that. And then it's going to give us a recommendation on that. The recommendation for the risk reassessment, if they score low or moderate, and then the visitation, if they're not supervised and the visitations are going well, and the kids are safe or conditionally safe, it's going to recommend that we reunify. However, if none of those factors exist, it'll recommend that we keep them at a home. So if the risk level is high or very high, if visits are still supervised, if safety is unsafe, it's going to recommend we keep those kids out of home. As well as it can also recommend we change our permanency objective. So if the kids have been out of home for 15 out of 22 months, the assessment will recommend that we change our permanency objective to whatever is appropriate at that point. One other assessment that can be done when the kids are out of home is an assessment of placement stability and suitability. And that would be when the kid's in a foster home and an intake comes in on that foster home. And that would be something happens in that foster home. There might be allegations of abuse or neglect. It's not quite the same as for the parents. We're not assessing necessarily that they're safe or unsafe. We're assessing if that placement's suitable for them or unsuitable for them. So the assessment looks a little bit different, and it's a little bit of a higher standard than it is for our parents for suitability or unsuitability. There are a few overrides in any of our assessments. There's policy overrides and then discretionary overrides. There are 4 policy overrides. And I can tell you what they are. There's sexual abuse and the perpetrator's likely to have access to the child. The non-accidental injury to a child is younger than 2. A severe non-accidental injury, and the caregiver's action or inaction resulted in death of a child due to abuse or neglect. And what those policy overrides do is automatically bump the level up to a very high risk level in any of our assessments. And then there's a discretionary override as well, where the CFS specialist can increase the risk level up just by 1 level or down by 1 level. And that's an automatic consultation point with their supervisor as well. If they feel like there's something that just wasn't captured within that assessment, and then they have to justify why they're doing it, and then the supervisor has to look over it and agree with that justification. As far as how often the discretionary overrides are used, it's very minimal. In the risk assessment, it's 1.9%. Prevention is 0.7%. The risk reassessment is the highest with 15.3%. And reunification is 3.8%. So it's not that often. For case closure, once again, we would always do a risk reassessment to close a case, and we will always do a safety assessment because we always need to make sure that that child is safe. And obviously, during a court case or a voluntary case, we should have a family team involved. We need to make sure that child is going to be safe and that all members of the team generally are going to feel comfortable with that. If the safety plan is still in place, we're not going to close a case. And if the child is not safe, we're certainly not going to close a case. Obviously, we can't ever with 100% certainty say there's never going to be another intake or there's never going to be another issue of maltreatment in the home, but that's why we have our teams and that's why we have our safety networks, and speak to everyone, speak to the collaterals to try to reduce that risk. And that's why we're trying to rely on our assessments too, because it will show us there's a low risk or there's a moderate risk. And that makes us more comfortable being able to close those cases, feeling that the risk has been mitigated by the time we're able to do case closure. Okay, I think I think this was mine. Sorry, Jay.
No,
for sharing our assessments, we do share our assessments with our families. They are able to work a lot more collaboratively with us when they know what's going on with our case, when they understand the purpose of what's happening with the case. When we make a safety plan, that absolutely has to be given to the family and to every single party that's involved with it. And I think Jay was going to speak more about how this can be beneficial to sharing with the court.
That's correct. Thank you, Justy. Obviously, transparency is an issue that is important to the department. We believe that if all parties are informed about the process, what is expected of them, then it makes everything go smoother. For those of you who are familiar with the process in family drug courts, in both the separate juvenile court and then obviously in criminal court, it works as well. The information that's being presented to everyone is so that everyone's on the same page and knows what to expect. And I believe the outcomes are generally better and there's less surprise for everyone. I want to make a couple of points. I've been keeping my eye on the chat, so I think now is a good time to address a couple of questions. One was whether there were people could get a copy of this presentation, and Deb has posted a link in the chat for a copy of the presentation. There's also a link in the chat for the PowerPoint itself, so you can download that and print it out for your reference in the future. There was a question, is there a value assigned to the number of complaints filed concerning a child's well-being? And the answer to that is yes, and perhaps Justy could expand on, when you say value, I don't think it's not a numerical value per se, but that is certainly one thing that is taken into account, correct, Justy?
I guess I'm not sure. Do you mean on the number of intakes that come in? Is that what the question is?
Well, the question was, is there a value assigned to the number of complaints filed concerning a child's well-being? So I guess I was taking that to mean perhaps intakes for a family.
Okay, yeah, there is. There is on the risk assessment, on the risk reassessment, and on the reunification assessment. Yes, that raises the level on all of those. Yes, if that's what the question meant. Yes.
Okay. I guess one other point that I wanted to make from a legal standpoint, and hope that the attorneys understand the difference, is the definition, again, between safety and risk. Oftentimes in the courtrooms I'm in, I hear those two terms used together, safety risk. Okay, for the worker evaluating using the SDM tools, safety is separate from risk. And if we can do a better job of remembering the definitions of those terms and how the department is using those differently, and get away from using them together, safety, risk, I think it'll help move things along in the court system, and help perhaps avoid confusion in the future as to what people are really talking about, because if you're coming from the same mindset of definitions, it would be helpful to everyone involved. I see there's another question. So if 15 calls have been received, what is the escalation need?
Okay, so it's once again those same assessments like the risk assessment, and then it'll be the reunification and the risk reassessment. Until you get up to probably around 3, until you get around to 3 or more, then it probably doesn't matter if you have 3 or 15. It raises the level of risk assessment, and they do divide it out for the risk assessment between abuse calls and neglect calls, but it'll raise your level. And I can tell you for like the risk assessment specifically, if you have like let's say 15 calls and half are for abuse and half are for neglect, and then if you normally have that many calls, you're probably going to have some open cases, at least some voluntary ones. If you have that many calls and that many open cases, that alone probably puts them at high or very high of a level. So it really does make a pretty big difference when you have a lot of past department involvement in those assessments.
Another question received is, if family declines to work on identified issue and it is not included in case plan, is such info shared with parties? So I guess I'm not sure when you ask such info if you're referring to the identified issue, or perhaps a clarification of that question might help. Unless you want to take a stab at that, Justy, I'm not sure.
Yeah, so you can put in your case plan a certain issue, like if they come in for substance abuse and they absolutely aren't going to work on it, the court is going to require it, let's say. You can put that and then the client refused to work on it. There's a box you can check and that will print off on your case plan. Does that make sense? So it will show all legal parties that the person's refusing to do it. I think that answers the question.
Okay. Another question, has Nebraska completed a validation study of the SDM? The answer is yes. In 2016, Nebraska DHHS completed an external reliability evaluation with NCCD to look at the intake, safety, and initial risk assessments. So I think that the answer is yes, and we're continually looking at, through our internal CQI process, to evaluate the assessments and the validity of it. And then a follow-up question was, if so, how has that study modified the current SDM? I don't have an answer to that. I don't know specifically what things have changed within the SDM from the time it was rolled out and statewide in 2013 until where we are today in 2020. I will, just for giggles, I guess, I will show this here. I don't know if everybody can see it. This is the book that I received when I first went through SDM training back in 2012. I was in Grand Island at the time, and Grand Island was one of the pilot areas that first evaluated SDM before it was rolled out statewide. And so this is a very thick binder, and I spent days in the classroom along with caseworkers training on these assessments and the process. So again, as Justy said earlier in the presentation, the workers really are trained extensively in different scenarios, what did the definitions mean, how to apply them. So it's not just a process where you check boxes. There's a lot more to it than that. So I hope everybody understands that and appreciates that. The SDM bench card is a quick reference that should have been attached in the materials, and if not, please just request it from CCFL, and I'm sure they'll provide that to you again. But it has on it a background of SDM, the overview of all the assessments, the timing of the assessments in relation to the hearings, and then what the workers should be able to describe based on their assessments. The bench card was developed, mainly for the judges when the SDM model was first rolled out. I know it was provided to all of them. Hopefully they have that handy and use it on a regular basis. And I do see that the bench card PDF link has been put in the chat. So it looks like we didn't stretch this out long enough, Justy. If there are more questions, we'd be happy to try and answer them.
Jay, this is Deb, and there was one question in the chat. What is the DHHS policy regarding providing assessment forms to parties when requested?
I did miss that. Thank you, Deb. Our policy is that we provide the assessment forms to the parties when requested, with the exception of one. That's the APSS, and that contains information that would be considered confidential because the assessment's really on someone or someones who are not a legal party to the case. If somebody desires to have that information, they just need to ask the court for an order to release it. If the court so orders, then we're going to provide that assessment pursuant to the court's order. See, there's another question. Is there a process for weeding out someone who's abusing the hotline number and are just calling 15 times for nefarious reasons? Justy, can you answer that?
Well, I wish so. But we, because of confidentiality reasons that that really anyone's able to call in confidentially, it doesn't appear like there is really a way to do that. So I feel like just one time in my area they wanted to file false reporting charges on someone, but people are able to call into the hotline anonymously as well. So it's very, very difficult to do, I would say.
I agree. Yeah. Obviously, we want people to be able to report. That's what leads to child safety in the long run. And I do agree that there are people out there who abuse the system. And in my experience, over 25 years in practice, too often it's a tool that disgruntled divorcing parents or separating parents seem to use, and that is unfortunate. There's a question about, what is APSS? Good question. I hate those terms as well. I should have used the full term. It's Assessment for Placement, Safety, and Suitability. And that's on a foster placement. So that's why I said they're not really necessarily a legal party. Is there a deadline on when legal team will receive safety plan? I'm not aware of a deadline. Justy, am I correct?
I don't think there's really a deadline, but our safety plan participants, who would be, parents and whoever safety monitors, should really have it as soon as it's signed and it's, reasonable to get it to them if they need it in a certain structure. Just as soon as it's available, I would think you should be able to get it, or reasonable to get it. But I don't think there is a deadline per se.
Okay. Another good question here. As the risk level can never be lowered due to prior intakes, is there a formula for overriding, such as how long ago?
Yeah, you know, that is one thing. So that would be like the risk reassessment, right? And that is one thing. A lot of the time, it can be high due to static factors, because sometimes it's like their past history with the department is always going to be there. Their mental health is always going to be there, you know, for parents. So it can basically always be high for them. So that would be when the worker might want to use an override, a discretionary override, and override it to moderate. That would be a reason they'd want to do that, because sometimes no matter how great those parents are going to do, it will never, ever be moderate because everything else is a static factor for them.
And the question to clarify, all accept placement assessments are available to parties upon request, and placement assessments are available with a court order. Yes. Now, understand that's the way it should be, and I understand across the state, perhaps some service areas do things a little bit differently, but that's my understanding of our internal policy as far as making assessments available.
Right. They should all be available upon request. And I know in some areas you maybe have an agreement where you're always going to provide, you know, whatever your safety. I know in our area we provide safety and risk at all removals. So that's kind of up to your area, what you have agreed upon.
Okay. Just to kind of close up, again, the bench card has been provided to everybody. It's in a link in the chat. And I would encourage everybody to print that out and have it handy for reference. Again, there's definitions that are contained on the bench card that are very useful in helping to understand how it is that the workers are making the decisions that they make through the SDM assessment tools. And I want to point out again, that safety and risk as used in terms of the SDM assessments are different. I often hear in court the term safety risk used as one word and one concept, and we would hope that after you hearing the webinar today, you would understand that when we do these assessments, that safety and risk are two separate items that are to be considered. So we hope you can kind of take that away from today's webinar. Justin mentioned the APSS, which is the assessment of placement safety and suitability. One reason why the department won't provide that without a court order is that it contains information that would be confidential, considered confidential, of a foster home. So the department doesn't believe it can provide that information without a court order. But as Justy said, the other assessment information can be provided upon request. So again, hopefully today we have met the goals of hopefully sharing with you the objectives of the SDM model. And we have time still for questions. Next question, which assessment did you say could only be shared with a court order? I think I just answered that, Michelle. The APSS, that's an assessment for placement safety and suitability. If a family is asked to work a voluntary case and they refuse, at what point does HHS not accept that?
Okay, sorry. We try to engage them in voluntary services. If we feel like there's a safety threat in that house, and we really can't mitigate it and can't engage them in voluntary services, we'll staff among ourselves at HHS, and then we staff it with the county attorney to see if we need to file a petition. So, but we really try to if we feel like we can work with them voluntarily, we really try to do that. And we try to be very upfront with the family, too. And I always say, this is not a threat. This is being honest with you that we're really going to have to discuss with the county attorney if you won't, kind of work with us. The last thing we want to have to do is to bring things into court, honestly, and to have to remove children. We don't want to have to do that because we all know it gets very complicated when we have 5 other people telling us what to do. But if we can't keep those children safe and the parents just won't work with us, then that's what we do.
And again, as a reminder, the department can ask the county attorney, but the county attorney's office is the ones who are able to file a petition. We can't file that through the department. Is there a comparison that is done between each of the assessments, specifically between the first and last assessment?
It's kind of included. That would be the risk assessment and then the risk reassessment. And it's a little bit included in the risk reassessment because you compare, a part of the risk reassessment is what was your initial risk assessment. So it can be like very high for your initial risk value, and then you come up with the end, what's your current one. So yeah, it's kind of within that risk reassessment, if that makes sense.
Are there still cases being screened for alternative response?
There are a lot because it was just approved that there was a randomizer where all of the alternative response cases came in, and then they went 50-50 to alternative response and traditional response, and that was completely taken off just very recently. And so now all of them that are coming alternative response go to alternative response. So yes.
Thank you. So you'll have the link to the PDF for the slides, and then of course there's the link, as we discussed, for the bench card, which I think is a very handy reference tool. I do see we have Judge Corey on the line. Perhaps he can speak as to whether or not he thinks the bench card is useful.
Okay. No, from my end, I appreciate the what was posted in order to give a perspective in regards to the specifically the definitions in regards to this decision making that's being used in regards to what the department's doing. So I do appreciate that, and I appreciate the opportunity that you all had this webinar today. So thank you very much.
Okay. Sorry to put you on the spot, Judge.
No.
Thank you, Jim. It looks like there's another question here. Has the department announced publicly in some form the results of the alternative response randomized cases? I'm not aware, Justy. Are you aware of?
I don't know. I don't know if someone else on the department here knows.
Why don't I'll jot a note down and see if we can get an answer to that, and perhaps get that information out to the people who are present through CIP. Deb, I think that covered all the questions. We covered the material. We thank you to everybody for spending your lunchtime with us. Hopefully this gave you kind of an overview and will be helpful to you going forward. Again, as I touched on, there's so much more here. You could spend days learning about this, and we just hope this overview will help you in the future with your practice.
Jay and Justy, thank you so much for providing this overview of SDM. And as a reminder, the bench card link is in the chat. The presentation link is in the chat. The CLE number is in the chat, so there's a lot of information there. And then also we will be providing the same webinar next week on November 16th. So if you know of others that would be interested in attending that webinar, please encourage them to attend this same presentation, just at it on a different day and time. So with that, I will close the webinar for today, and hope that everyone enjoys the rest of this sunny, beautiful day, and will take care. Bye.